Hello, this is Matt on the Moon Lambeau channel. If the SEC versus Ripple case were to be turned into a movie, I don't know if it would be better as a drama or a comedy, but I can tell you this, the nonsense is continuing. Ripple's really taking the SEC to task in based on some recent conversations that they had on the topic of what information the public, yes, that would be you listening to this, should have access to. You're not going to be surprised to see that the SEC wants as little information as possible to be public, which is really peculiar, as attorney Jeremy Hogan points out. I'm going to share with you what he had to say, as well as XRP community member and attorney Fred Rispoli. It's ridiculous, so go ahead and buckle up. But before we go further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos all up on the internets, but about crypto, but just as a hobby and just for fun. Now, I will point out quickly before diving in, it is good to see mainstream media following along with the story. Here's a Reuters headline on what I'm about to cover. Ripple slams SEC bid to shield experts in high-profile crypto case. I'm not going to cover the story. I just wanted to point it out. It's pleasant. I'll take any mainstream media coverage we can get. Now, crypto media, they're pretty well all over. At least certain crypto media outlets are. Shout out and credit to XRP community member and attorney James K. Filan for sharing a number of the most recent legal filings, including this one where he wrote the following. Breaking, defendants and SEC in brawl over expert reports. SEC is taking the extreme position that the names of its experts and any substantive criticism of the reports should be kept from public view. So I'm going to share with you, I did print these up, and I'm going to share with you the parts that I found to be most interesting, and then give you perspective, like I said, from a couple attorneys within the XRP community. So I'll go ahead and make these full screen for you now here. So this is from Ripple's legal team, what's on your screen right now. And this has everything to do, just to be clear before I even read any of this, what we're talking about is expert witnesses. There's a debate over, well, in particular, the SEC's expert witnesses, how much of what they're reporting should be available to the public. So mind you that these expert witnesses are paid by the SEC, which means they're taxpayer funded, and they're allegedly professionals and experts within the field of crypto and blockchain technology, and some of them even just analysis in terms of tracking all sorts of things from a statistical perspective. And so geeky math nerd types as well. And typically, this type of information, the vast majority of it would be available. The SEC is trying to make sure that all of it is hidden from us. And I'll tell you right now, the SEC is seeking to hide the facts from us, the XRP holders, because they know that public sentiment is against them. Almost 100%. I'd say it's at about 99.99999% of people following this are against the SEC. And so they're trying to reduce the amount of damage. That's my perspective. So just understand that going into this. So anyway, Ripple's attorneys wrote the following. Dear Judge Torres, the parties are scheduled to file their daubert motions on Tuesday, July 12th, 2022. So I'll just pause to note, daubert challenges, what's being referenced here, is challenges against the expert witnesses of the opposing side. So if there's a daubert challenge or a daubert motion, then what you're asserting is against the other side's expert witness that either they're not actually a legitimate expert or the methodology that they're using to come to the conclusions they're coming to don't make no damn sense. So that's what when they say daubert motion, that's what they're referencing here. Anyway, Ripple's attorneys continue. Defendants' right to seek an expedited briefing schedule on the extreme position taken by the United States Securities and Exchange Commission that the names of its experts and any substantive criticism of their reports should be kept from public view. That's right, folks. That's exactly what they're doing right. That's how extreme this is. And you may recall there's one of their experts, his name Patrick Duty, and the SEC has alleged that there have been harassment and threats against this individual. I don't know what those are, but as a result of that, they're now crying out saying, well, we can't risk having that happen to anybody else. And so they're using it as an excuse to prevent you, the public, from seeing their nonsense BS arguments, because they know that the crap that they're spewing is not being bought by anybody out in the general public. Anyway, Ripple's attorneys continue. They write, as the court is aware, there is a pending SEC request to seal information identifying one of the SEC's experts, expert number 1, and the substance of his testimony. So I'll just pause to note that would, of course, be Patrick Doody. That's the one that we learned some time ago, many weeks ago, where there are these allegations of threats against him. And we can all get behind the idea of nobody should be threatened, even if they're on the opposing side. You don't make threats against individuals. That's completely unacceptable. The concern here is he really been threatened? Well, Judge Torres ultimately chimed in on that, but that's a little bit later in the video. Anyway, the SEC has informed defendants that they will seek to extend that relief to 3 additional experts. Okay, so what they're saying is we already knew that we wanted to seal the expert testimony, the expert reports of Patrick Doody, and now the SEC informed the SEC informed Ripple that regarding the rest of their experts, they don't want that information out in the public either. Now, at this point, at the time Ripple wrote this letter, that motion hadn't been filed. The judge hadn't considered it, which means that technically Ripple could have done whatever they wanted, but they didn't, as you'll see as I go a little bit further in the video here. But they just decided last minute, the rest of our experts too, we better be on the safe side. Nobody gets to see any of that either. And then Ripple's attorneys wrote the following. The report of Expert 5, including his name and affiliation, has already been filed on the public record by the SEC. The SEC nonetheless insists that defendants redact even Expert 5's name and any identifying information from its daubert motion and the exhibits thereto, including his report, which is already public. So, just pause to note here, we're supposed to pretend that it's not already public then. Like, we're really like that. Look, it's already out there. You have access to it right now. You can go get it. I've highlighted portions of it because it's publicly available, right? And now we're just supposed to pretend like it doesn't even exist. And then Ripple's legal team wrote, the SEC's attempt to shield the identities and opinions of its experts from any public scrutiny is both unprecedented and unsupported by any evidence of need. It is antithetical to the right of the public to have access to substantive materials that will be critical to this court's upcoming rulings on the parties' daubert motions. The substantial presumption of public access is strongest where, as here, materials filed with the courts go to the merits. So the SEC's attempt to suppress public criticisms of its experts' opinions is particularly egregious, given that none of the SEC's expert reports is likely to contain SEC confidential information. So listen up here, and this is where my ears really perked up. They say, and this because you know this is true, the only confidential information in the expert reports is internal information about Ripple itself and third parties. The SEC is abusing the protective order in an effort to prevent criticism of its experts from reaching the public. And folks, that is exactly what I think is going on here. This is not grounded in reason or reality. And so what Ripple's attorneys are saying here is that the only confidential information that would be in the SEC's expert witness reports would not be confidential information about the SEC. It would be about Ripple. And Ripple's saying, let it out in the public. You know, if Ripple's not even saying don't let it out in the public. It's the SEC. It just doesn't make any sense. And you know why. It's because when the SEC filed this damn case, they had no earthly idea that for the first time in history, something so unprecedented would happen, to the extent that over 68,000 XRP holders would request that the SEC sue them so that they could participate in the court. And so now you have John Deaton representing over 68,000 XRP holders as amici curiae, which is friends of the court, actually participated in the SEC versus Ripple case, the most consequential lawsuit ever in the history of crypto and blockchain. And it's certainly not too much to say that this is going to be precedent setting, no matter how it goes. This one's going down in the history books. That's for sure. That is, if anything, that's an understatement, to be perfectly honest with you. That's how big this is here. And then they also wrote, given the SEC's confidentiality designations, defendants have no choice but to file 4 of their 5 daubert motions and exhibits under seal pending a court ruling on the SEC's position. The daubert motion as to Expert 5 will be filed at the SEC's insistence, provisionally sealing that expert's name and other identifying information. So just pause and note what they're saying here is basically Ripple, we are self-censoring. They're censoring themselves. That's what they're doing. And they didn't have to because there was nothing even filed by the SEC at this point. The SEC just told them that they intended to file such, and as a result, this is what Ripple did. They filed their 5 daubert motions and exhibits under seal pending a court ruling. It's under seal, so we don't get to see it, at least not at the point that this was written anyway. But we actually do have, as you'll see as I go through the video, we got a bit of a happy ending, almost perfectly happy ending, but I don't want to get ahead of myself here. So then there's this. Attorney Jeremy Hogan, he had to say the following on this topic. He wrote, "This case, again, is ass backwards, with the prosecutor, the SEC, attempting to hide everything. Normally, in these cases, it's the company that wants to hide things from the public. Judge Torres was shown a slant towards disclosure. Judge Torres has shown a slant towards disclosure, so I don't think she'll seal what the SEC hopes." So pause to note again, this is in line with exactly what I've been saying. As Jeremy Hogan very intelligently points out, the SEC, that's unprecedented. They're the ones that want to seal stuff, and Ripple's like, no, let it out in the public. Well, then who's the bad guy? You tell me who the bad guy is when the SEC, which is supposed to be protecting us, doesn't want us to see the facts and circumstances of the case, but the defendant, Ripple, does want us to see the facts and circumstances, even when it's about their confidential information. That's really telling, is it not? And then Jeremy Hogan wrote, "The motion is not super clear, but I think this means we will not see any of the motions to strike that will be filed this Tuesday, and I was looking forward to the motion to strike duty." And so at this point, and again, like I said, we do have a happy ending, but that was the best thing to suppose at that point, was that based on what Ripple had written and how they were filing all these daubert motions under seal, we weren't going to see any of this stuff. And I was looking forward to it too. Anytime Ripple's legal team tears to shreds the SEC, I have a good time reading it. As miserable as this court case is, at least we get to enjoy that part of it, right? And then attorney Fred Rispoli responded to attorney Hogan, and he said, "As a more aggressive litigator, which is not always a good thing, I would have told the SEC the burden is on you to get an order from the court to seal, and we are filing publicly. I just don't get why Ripple lawyers aren't playing more hardball. The law is clearly on their side." And so what he's saying here is, if it were him, if he were Ripple's attorneys, even though the plaintiff, SEC said, "Hey, we're going to file a motion to the court because we'd like all these to be under seal," Ripple didn't have to play ball because the SEC hadn't filed anything at that point, but they just did it anyway. They acquiesced. And so Fred Rispoli is saying, I don't really like that approach. And fair enough. I'm not the one with the legal background, so I don't know. The only thing I could say is, and I'm just speculating here, and as far as whether it's for the better or worse, I don't know for sure. But one must assume, right, that since Ripple took this approach, they didn't want to look perhaps unnecessarily aggressive. And if they knew, maybe they're worried about what the judge would think if they're like, "But Ripple attorneys, if you knew that the SEC didn't want this and they were perhaps going to be filing something, then why would you take this action?" So maybe part of it was imagery and trying to stay on the good side of the judge. Maybe it was something to that effect. And maybe it's not going to matter. Look, I'll say this. The only thing that would impact is public pressure, whether or not we have this information, because it's going to impact our natural response, whatever it is. But it's part of the court case no matter what. So in terms of how it impacts that, no. It's crazy stuff. And then somebody named Relly Rich responded to attorney Hogan and said, "That's the point, to wait until the last minute." Oh wait, did I not read that one? Oh, I'm sorry. Did I read this one from Hogan? So Hogan responded to attorney Rispoli. Sorry, I missed one. And attorney Hogan said, "And it's not like the SEC hasn't known about this deadline for what, 2 months now? Plenty of time to file a motion and not wait until a week beforehand to raise the issue." And then an XRP community member named Relly Rich wrote, "That's the point, to wait until the last minute. They've done it every time so far." And attorney Hogan says, in response to that, "This time Ripple could have made them pay because the burden is on the SEC to file a motion to seal, and have it heard, and unless there's an order saying otherwise, you file anything you want. At least that's what Fred is saying he would have done. Hey, fair enough. And then we did get a ruling from the judge. So take a look at this. And again, shout out and credit to attorney James K. Filan, who shared this, and he wrote, Judge Torres has granted in part and denied in part the party's request to seal documents in connection with the Amici motion to participate in the daubert proceedings. Proposed redactions are due by July 15th, 2022. So let's break down just a little bit of this right now. So here is the actual filing here, and this looks gigantic. Maybe I should zoom out a little bit. Why is it by default? By default, when I loaded this, is at 175%. Like WTF, Bill Gates? Like what's going on here? Anyway, I can throw that one out. Okay, so there's only a couple parts I actually highlighted in this because I think I can get the ideas across without boring with you a bunch of the legalese and like the legal precedent and so on and so forth. I do my best to just try and get to the meat of it while making sure I'm not skimping too much. It's kind of a balancing act and rather subjective as to what the hell that means, but I'm doing my best here. So this is the actual order. And the couple parts that I highlighted, I think, so the first part was on actually page 4. Here we go. There we go. With, it's around here somewhere. Did I miss? Oh, I did scroll too far, I think. There we go. This part right here, which starts right there where I just highlighted. With respect to the redaction of footnote 1, the SEC contends that this footnote... Oh, no, damn it, I did skip ahead. No, it was page 3. Amateur hour, unsubscribe. Sorry, folks. A rare Moon Lambo mistake. That one's going down to the history books. All right. Yeah, there we go. One page too far. With respect to the SEC letter, the court finds the SEC's proposed redactions to be proper and shall permit them. So let's pause to note, this is where the SEC wins. They do win on this, but I'm telling you, I'll explain why in a moment. I don't think this is particularly consequential in terms of what the public is going to see. And then the judge writes, and this is Judge Torres, these redactions are narrowly tailored to prevent the disclosure of arguments and evidence related to the harassment of the expert, and the court agrees that public dissemination of this information may increase the likelihood of future threatening behavior, implicating concerns of witness safety and the danger of impairing judicial efficiency. So again, they're certainly talking about Patrick Doody here, and whatever threats were against. I've not seen them. I don't know. I know nothing of it. I just know that there are the assertions, and the judge seems to agree. And we did learn within this that those threats came in the form of tweets all up on the Twitters. That's what it was. There's some mean tweets. Like, welcome to the internet, though. Like, it's a cesspool. Okay. So it is what it is. I don't know how bad they are. It's like, look, there is such a thing as crossing the line. Maybe I'd look at it and be like, oh, yeah, that definitely, that's definitely threatening. Maybe I would think that. I don't know. I've never seen them. But maybe I would. Maybe be like, okay, that's a little limp-wristed there. Like, you're a little soft there. You know, I'm just saying, you're a little light in the loafers here. I don't know what's going on. And then there's the part where Ripple wins, and it's on basically everything else. So here we go. And it's right here where I'm highlighting. With respect to the redaction of footnote 1, the SEC contends that this footnote, which includes information about the substance of the expert's report, could, and this is the quote from them, inflame the discourse and result in further harassment and intimidation of the expert, end quote. So they're saying here that even outside of specifics directed at Patrick Doody, for example, just the public seeing the facts within this expert witness report would inflame the public. Just the facts and circumstances of what's in there. We are just ravenous creatures. We cannot handle the facts and circumstances. We are bad creatures. Like, do they think we're cottage cheese eating, Velcro shoe wearing, Bitcoin maxi trolls? Holy hell. I'll tell you what, I don't wear a helmet when I go into the outside world. I am not a Bitcoin maxi troll. I swear on my life. But that seems to be what they think we are right here, wandering around going, Bitcoin, and then staying warm next to the dumpster fire under the bridge. Doesn't make no damn sense. And so the judge wrote this, though, and this is the money shot. The court disagrees that the public should be prevented from accessing information based on concerns that it will provoke strong feelings. That's right. Oh, you little snowflakes. You know? No, but seriously, like, the idea of not sharing public information that should be public anyway, because it might make somebody feel mad to some degree, or upset, or frustrated, are, disaffected in some way with how the SEC's operate. Like the fact that might, not that it will happen, but that it might happen, and we don't know because we can't see the future. That means that we just say screw it all as far as transparency goes. No, thank you, sir, or madam, says Moon Lambo. Get the hell out of here with that nonsense. Not in my house. So here we have more feedback from attorney Jeremy Hogan on exactly this, and he wrote, Judge Torres is not allowing the SEC experts' opinions to be sealed just because they might inflame the public. Not only does she not allow the parties to keep relevant documents from the public as to this motion, she chills the SEC's pending motions to seal. It's a 2-for-1. It means we, the public, get to see the expert witness reports, except for a small part of it that somehow was directly related to the harassment sent the experts' way. That's literally what all this stuff recently has been about. So it gets a happy ending, ultimately. And if there really is something truly harassing and just over the top and unsafe, then I get behind that. I really would. I just haven't seen it, and I know that the SEC's liars, just a bunch of liars. And I could see a judge just wanting to play it safe, even if it's not that bad. So who knows? I can't say. I tend to think that both Judge Knepper and Judge Torres are doing very good jobs, even though we'd love every ruling to be in favor of Ripple and or XRP holders. But look, all things said and done to this point, if you were tallying up the wins and losses and all the pretrial stuff, I think Ripple and XRP holders are way out ahead at this point, honestly. We're in the lead to this point anyway. And here's what attorney Fred Rispoli had to say about this. He said, called it right except for Torres ordering publication even where parties agreed. Happy to be wrong on that. More transparency is always better. Only disappointment with ruling is that I don't think a judge should base redactions on tweets without authentication. Could have been SEC. Yeah, and so point well taken on that. And it was good to see that, actually. And I didn't highlight the specifics in the order, but just for the sake of time. But the judge did state, as Fred Rispoli is citing there, that where Ripple and the SEC agreed that perhaps redactions are fine, the judge says, no, that's transparency here, actually. No, you're not getting that. So that was good to see, actually. And then, on top of that, the point on from Attorney Rispoli about the tweets, that's the other thing. Like, were the tweets bots? Were they real? Were they actual humans? Was it a setup so that the SEC could actually make these assertions and keep this information from the public? What if it was somebody from the SEC? Like, prove that they are authentic. Seems reasonable, although at this point it does look like it's already said and done. But I certainly do appreciate the insight. I'll go ahead and wrap up there. There's going to be more in the case in days to come. There's a lot of big stuff that we're waiting on, including a final determination from Judge Knepper on the attorney-client privilege assertions that the SEC has made regarding the Billy Boy Hinman Ethereum free pass stuff, because they're saying, hey, you shouldn't get to see any emails or drafts of the Ethereum free pass speech associated, from Bill Hinman and his cohorts, because there's an attorney-client privilege there, which is nonsense. Bill Hinman is not a client of his employer. He's just employed there. It's ridiculous, but I'll wrap up there. I'm not a financial advisor. You should not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Lambo.